Yeah, but I would agree with you. I can think of some Jesus one. He got.
Good afternoon. Good afternoon.
Good afternoon.
So, we'll get started once the screen warms up. But I just want to check in and make sure that like everybody's okay. Right, we're early in the semester. You guys are still, sort of getting your feet under you. Yeah, we're all just trying to make it through together. And so if you all already find yourself feeling overwhelmed, if you already find yourself feeling like you are struggling to keep up, come and talk to me and we'll see if we can come up with a strategy to help you out. So, all right. We have our idealistic lawyer who's trying to help people, and he set up this sort of informal clinic kind of environment at the YMCA, and he's attempting to help them. And we're not going to use Socrative today because I forgot to log in. So this is just for you guys. So if you're logged into Socrative and you're like, why isn't the activity going? That's why, because I forgot to start it. So don't worry about it today. So he is specifically declining to represent these folks. Okay, there's a disclaimer they sign that says we're not imposing any sort of obligation to provide legal representation, and it's just, look over documents, collect a small fee, maybe some minimal advice, and send them on their way to handle the things pro se. So, given the disclaimer, is the attorney correct in believing that no attorney-client relationship exists? Nope. Once again, here are your choices. Take a minute. Anybody who would like to take a stab at answering this, give us what they think the right answer is. Yeah, Mr. Thompson.
B.
Okay. Why?
Because he is giving legal advice and he does have a type of relationship with the clients, even though they're pro se. And I believe that would fall dot 2C, where a lawyer may limit the scope of the representation if the limitation is reasonable under the circumstances.
So,
And the client gives informed consent.
is there anyone who wants to disagree with Mr. Thompson? Yes, Ms. Burrow.
I think C, because we don't know that they understand that they're signing this saying that this person is not providing legal services. We don't have an attorney-client relationship.
Okay. So, anybody else? Last chance. No? Okay. All right, so Mr. Thompson is correct. We do, as the question recites, have functions that are defined as the practice of law, right? It's not just going to court. It's, giving advice, reviewing documents, etc. And we have the attorney-client relationship. Now, I'll throw this one at you. The question says that the attorney collects a nominal fee. Would the answer change if the attorney was not charging a fee? Lots of folks shaking their heads. So, Mr. Owen, why not?
Can't remember which rule exactly, but I think no matter what, if you're charging a fee or not, you have the same duty to who you're representing.
Absolutely right. Okay. And I will tell you guys, for MPRE questions, you do not have to know which rule governs the question. Okay. Now, for the final in this class, that will be helpful. Knowing which rule is the right rule will be helpful. But for the MPRE, it does not ask you to cite to authority. It just asks you to apply the rule. Okay. So as long as you know what the rule is, you don't have to give us the right rule. So yes, B is still correct, even if the attorney isn't charging. Okay. Now A tells you that, hey, they signed on the dotted line, or you're off the hook, right? Right? That's what it says. So that is exactly what the fact pattern claims, but that's not what the rules say. In fact, the rules are explicit that we are not allowed to contract around the rules of professional conduct. Now, Ms. Barral is correct that the fact that these clients are unsophisticated should give us pause. However, because the question is asking, is the more sophisticated person's understanding correct? That lack of sophistication should lead us toward the notion that, in fact, they're wrong. Okay. And then again, as we said immediately at the beginning, you don't have to go to court to be engaged in the practice of law. And so D's emphasis on he's not going to court, he's not appearing on behalf of these people, that's what makes it wrong. All right. Questions about number 7? Okay. Number 8. This is the Westboro Baptist question. So we all know who those folks are. We're not going to go down that rabbit hole of talking too much about them. But here's the question. Okay. In response to press questions, the lawyer says, I don't agree with these folks. I am just here to represent their legal arguments. Is that proper? Here are your answer choices. Take a minute. Yes.
I didn't get to read the whole fact pattern. What was this? Is this after the resolution of the case?
Yes. Although Mr. Becker raises an interesting issue. And we'll talk about it in just a second, once we sort of deal with this question. So, does anyone want to take a stab at answering this one? Yes, Mr. Rhoda.
Yes, I did.
Okay, why?
Because I think as long as you do not need to share any political or religious belief with anyone before that.
Okay. Does anyone want to disagree? Argue that there's a better answer? Shoda is correct. Exactly right. Okay. We want, in an adversarial system, we want clients to be able to put forward their strongest arguments so that we can feel confident that the results reached are correct. And so we have this norm in the profession that we expect attorneys to represent clients regardless of their feelings about the client's views. Okay. And so A mentions that, there's some sort of different issue depending on whether you win or not. That's absolutely false. And it doesn't matter, right? We could be talking about Westboro Baptist. We could be talking about the Poor Sisters of Charity. We could be talking about Puppies and Kittens United, right? Doesn't matter. Us appearing on behalf of the client does not imply that we endorse their views. Okay. Now, B is incorrect because it states the rule in the United Kingdom. So in the United Kingdom, they have what's called the cab stand rule, where barristers in England and Wales and barristers and advocates in Northern Ireland and Scotland, but not solicitors in England and Wales. And we're not going to go down that rabbit hole. But basically, most of the legal profession in the United Kingdom has an ethical obligation to accept any client who requests their representation and can afford their fees. Okay, so the way that British lawyers duck out of clients they don't want to represent is they quote them astronomical fees. But in the United States, we do not impose that rule on attorneys. You guys get to choose whether you're going to accept a client or not, or whether you're going to offer representation, right? The power of acceptance lies with the client, but you get to decide whether you're going to offer representation. And so you also do not have a duty to accept any client that comes your way. So, and you also don't have a duty to only accept representation you agree with. In fact, we encourage you to represent unpopular clients whose positions you don't agree with. Okay. And finally, right, just because you represent the client doesn't mean that even during the course of the representation, you have to like put on this face that they're right. You're allowed to say, my clients are, they're lying sacks of crap, but their claims are sound, and we should validate them. Okay? Questions about 8? All right. Question 9. This will just take a minute. This will just take a minute. A week later. No, this is the real, this will just take a minute, right? Client calls the lawyer, says, I have a fairly simple question. Lawyer says, well, it's not quite as simple as you think it is, but it shouldn't take me a lot of work to get it done and to draw you up something that will express an opinion. But I can give you sort of a quick and dirty answer off the top of my head. Client says, quick and dirty is good enough. I will take the answer that you give me over the phone. Attorney says, great, here's the answer. They get off the phone. Attorney sends a bill for, the 10 minutes phone call. Okay. Is this proper conduct for the attorney? Here's your answer. Here's your choices. So take a minute. Anybody want to take a stab at it? Question.
I say A.
Okay, fine.
Well, the lawyer did perform with the due diligence of what was asked of them at the time. The client wasn't wanting anything more than just a quick answer to a problem in front of them, and the lawyer took the steps to offer further advice, but the client declined to not offer, and then they agreed on the billing and the rates, and the client seems satisfied with the service.
Okay. Anybody think that maybe Mr. Questy's wrong? No? Okay. Well, he's right. One thing that I want to flag for you is that for limited scope representation like this, both the attorney and the client have to agree that the limited scope is appropriate. And so if the attorney had said, hey, this is a really complicated question, you know, I'm not sure I've got it right, I need to do some research, it's going to cost you some more money. And the client said, no, whatever you know off the top of your head is fine. Then the attorney would have to say, then I'm sorry, I can't help you. Okay? Because we have a responsibility to make sure that clients get not what they want, but what they need. Okay? And where those two diverge, we have to go after the latter. All right? So, B raises a whole bunch of irrelevant stuff that's all true and all correct, but doesn't actually help you resolve the question based on the facts presented. And then C and D both misstate the facts for various reasons. Okay? Questions about that? So guys, are you starting to see like how the NPRE operates and like the tricks that it uses and the ways that it tries to fool you and the things you need to be on guard against? Okay. We're going to keep working on this until the actual NPRE in March, and then we're going to stop. But like, I want to point out for you guys that like, this is how this process works. Okay. In that we are explicitly engaged in this skill development of helping you learn how to deal with the nonsense that the bar asks of you. Okay? All right. Questions? No? All right. Okay. Okay, so for more or less the rest of our time between now and spring break, we're going to be talking about the duties and the rules that govern how we interact with clients. And then after spring break, I think we'll wrap up that sum, and then we will transition into talking about the rules and duties that govern other relationships. But I think there's sort of two most important ways to think about the attorney-client relationship from a professional responsibility standpoint. And that is, first, who decides the answer to any given question? And second, who's first? And this one's phrased a little oddly. Basically, what I mean is, whose interests have to come first? Okay. So I want to talk about the question of who decides first. All right. understanding what are the things that the client is responsible for deciding versus what are the things that you're responsible for deciding as the attorney. This is going to be one of the most important things that helps you avoid issues related to Rule 1.2. Okay, so we're going to work through a few hypos. So, Mr. Shrestha, who decides if the lawyer is competent to handle the representation? By the way, the choices on these are the lawyer and the client. So if you have to guess, you have a 50-50 shot. Now, for those of you who are in my CivPro class, what's your reward for answering a question with a 50-50 chance of being right?
Follow-up question.
Which is?
Why?
Why? So, with that warning in place, Mr. Shrestha, who is responsible for deciding if the lawyer is competent to handle the representation? Is it the lawyer or is it the client?
Lawyer,
Why?
because lawyer have to look upon all the facts.
What do you mean by all the facts? Like expand on that a little bit, please.
Lawyer have to know all about the clients,
Mhm.
information and facts, and he have to do it to all. The lawyer is responsible for that.
I mean, I think that's right. You're right that it's the lawyer who decides. But let's see if we can unpack a little more about why that is. So, Mr. Cruz, can you think a little bit about like who's in a position to know whether the lawyer is competent?
The lawyer himself, or if it gets to the point where it goes to a court, the court would determine that if the person filed a suit saying that the lawyer was incompetent, then the court would. But anyways, the lawyer would, because he would need to determine that he has sufficient knowledge of a particular area of practice before he takes the case.
And how would he know that?
Um,
Well, how would he know whether he did or not? Like that, let me phrase the question a little more precisely.
I mean, I would gauge it by experience that he's never handled a case like that before, has never read anything on it.
You sound so uncertain, and you're exactly right. You're exactly right. Okay, so right, who knows what your experience is like better than you? Okay, and I want to emphasize that. Who knows what your experience is like, your personal experience, better than you? I hope you see that as the empowering kind of question that it is, because it means that you have the right to look at everything that you've done and to ask yourself, am I ready for this? Or, right, if the answer to am I ready for this is no, you are also allowed to ask, can I get ready for this? Because Rule 1.1 does not require you to only take representation where you already know how to handle it. If that was the case, let's just send you all home because you're never going to be able to take your first case, right? But Rule 1.1 allows you to take cases, to accept representation where you will become competent. Okay? So you are allowed to grow as a person and as an attorney through the course of your career. Okay? I cannot emphasize how important that is that you have this, power, that you have this ability. Okay? Like, you are not locked into anything. You can do everything. The rules allow it. Let your reach exceed your grasp. Okay? Oh, Captain, my Captain. No, but yes, this is absolutely correct. Who decides whether you are competent? You do. Okay. So, next question. Ms. Hovde. Did I pronounce your name correctly?
Yeah, it's pronounced different every, you can pronounce it.
Well, how do you pronounce it?
Humpty.
Hovde.
Yeah.
Okay.
I did not marry for the last name.
Well, if it's any consolation, neither did my spouse. So, okay. So here's my question to you. Who decides what the goals of the representation are while you're a client?
The client is gonna decide the ultimate goal, but the lawyer.
That's the question I'm asking.
Okay.
So I'm going to cut you off because now I want to know why does the client decide make that decision?
Because it's their life that's gonna be impacted, and the lawyer's the one who's representing them and their interests, and so they're conducting the shift, pretty much.
Exactly right. Exactly right. Okay. In fact, so exactly right, I have nothing to add. So, Mr. Green, who decides how the client's goals, right? So we've just talked about the client's goals. Who decides how those goals should be pursued? Okay, why?
They have the expertise, the experience, and even though it may not be a route that a client from the outside looking in would think is like the right way to go, the lawyer knows better.
Okay. Exactly right. I have one follow-up, Mr. Presby. What should the lawyer do if the client attempts to dictate how the client's goals should be pursued?
I think the lawyer should just make sure that then those goals stay within the ethical and legal boundaries of the law and the practice. There are.
Client's not asking you to do anything unethical, right? Let's sort of make it a little more concrete for you. That might make it a little easier. Client says, I want you to hold opposing counsel to every deadline. Don't offer any extensions, no courtesies. I'm furious at these people. I want to make this as hard as possible to force them to come to the negotiating table. And then opposing counsel calls you up and says, hey man, I just got a call. My grandfather just died. You know, I know that discovery is owed to you tomorrow. Can I have a couple of weeks to get it to you? What do you do?
That situation. Personally, my first step in this situation would be to first speak to my client and address the situation.
See if we can help him out. Mr. Durkee.
It's the attorney's representation on the line there, not the client's. So, I mean, if that was kind of, if they were trying to do something outside of what I was comfortable with, I'd just tell them to find another attorney or represent themselves.
Ms. Gleason.
I would agree. I would definitely communicate with my client, but I would communicate that there's been a hardship here that's serious and that we need to grant the
Mr. Owen?
extra time.
I agree with them. I think the ultimate goal is to get them to the negotiation table in your scenario. But it's the lawyers.
So let me make this very, because I do not regard this as a hard question at all. Things related to deadlines and, like the civility and collegiality of how the lawyers are handling the case, that is none of the client's business. Client has no business giving directives on that topic, and you are under no obligation to follow them. So you grant the extension, you say nothing to the client, and what they don't know doesn't hurt them. Now, if the client is insane enough to be watching the docket so closely that they catch you in this, then okay, maybe we're dealing with the situation that you guys are talking about of saying, we're handling this with due attention to your goals, but we had a compelling reason for granting this extension. And if you don't like the way we handled it, you're welcome to find other representation. Okay. But speaking as someone who spent most of his career representing relatively unsophisticated clients who would not have known how to read a docket sheet if one had been put in front of them, if you're doing that kind of work, they're never going to find out. So they give you this nonsense directive that you're not obligated to follow. You just go, oh, okay. And then you do what you need to do to pursue their interests in a manner that is appropriate. Okay. So, all right. Next question. All right. Who's on the hook? Ms. Harding. Ms. Harding, thank you. Sorry, you're on the other side of Mr. Thompson on my seating chart. It's fine, you don't have to move. That's why I was looking over here. So Ms. Harding, who decides whether the attorney will represent the client?
The attorney makes that decision first. They go through and see if there's any conflict of interest, or if they do like a little self-assessment and see if they know enough about this or are willing to learn enough about this. And so they ultimately decide first.
Okay. Do we agree with that? Mr. Henninger, you're making a face like you've seen something in your oatmeal. So do you agree with that?
I thought it'd be like both.
Anybody else? So clients decide. Clients choose who will represent them. It's a little bit of a trick question. Because, Ms. Harding, where you are correct is that attorneys decide the scope of the representation. Now, there may be lots of reasons why the scope of representation that the attorney is willing to offer is none, right? As you say, conflict of interest. Maybe the attorney self-assesses and says, I'm not competent to do this and I can't get up to speed, right? Or the attorney says, okay, I'm willing to help prepare the forms, but I'm going to send you off to court to file them. Okay. I actually did this quite a lot when I was a bad divorce attorney. So one of the family law judges in the court where I practiced had taken such an intense dislike to me that it was literally impossible for my clients to obtain relief in front of her. And so if someone came to me and they wanted to file a divorce, or they wanted to file, a custody petition or anything that would have been in her court, I would take a small fee. We do a limited scope retainer. I'd prepare the initial pleadings, and then I'd send them down to file it. If the case got assigned to her courtroom, then I would refer them to another attorney to continue the representation. If it got assigned to one of the other judges, then we come in and we do a full scope retainer. And I continue the case. So, so you, as the attorneys, you decide what services you are prepared to offer and on what terms. The client decides whether they are willing to accept those terms and whether that scope is sufficient for their needs. So you decide what you're going to put on the table. Client decides if they're willing to take it. Okay. Let me ask you guys this. How would you respond? How would you want to respond if, in response to your offer of representation, right, scope and terms, the client attempts to negotiate? What would you do? Yes, Mr. Baker.
I would probably say, depending on what it was, I would probably tell them that the scope and the terms were things that I personally felt I have to comply with. And so there would be no negotiation unless it was very limited, maybe.
Anybody else? You said it would be very limited. What are things that you would be willing to negotiate on?
I don't know. I'm not really sure what kind of things come up at this point.
Fair enough. Mr. Owen?
I think I'm telling them it's non-negotiable. Like I'm telling you the terms, now you can decide whether that's for you or not.
That is certainly something you are entitled to do, right? What I will tell you is that, like, I mean, sometimes you don't have control over the negotiability of terms, right? If you're in a firm environment and the firm has a standard contract or like maybe a set of standard contracts, right? These are the kinds of terms that we can offer. And you may not be in a position to negotiate because, you know, you don't have that kind of control. Or, right, if you're out on your own and, you know, maybe it's been a lean couple of months and you gotta take the business that comes along. Maybe you are willing to negotiate in those kinds of situations. Tell you one story. I had a potential client come to see me and we did the intake interview and looked like there was a claim. So we offered him representation using the standard terms that we used for all of our clients like this. And he started trying to negotiate. And we had and what he was trying to do was basically set up the financial side of it so that, because it was a contingency contract. So, you know, one of these, we don't get paid unless you win. And it was structured in such a way that, you know, we took on as much of the risk of non-payment as we were comfortable with. And so he would start trying to negotiate this so that we were taking on more of the risk in exchange for more of the upside, right? Reasonable trade, right? Reasonable to ask for, but not a trade-off we were willing to make. We had written the contract to put ourselves in as much exposure as we were prepared to do. And we told him that these were the terms. We were not open to negotiating them. He could take them or leave them. It was at that point that the potential client said, and all of this business was done over the phone. So he never laid eyes on me. So I want to emphasize that when I say this. This was the point where the potential client says, well, look, I'm not trying to Jew you down. And that was the point where we said, you know what, we don't think we're the lawyers for you. And we're very sorry, we don't have anyone to refer you to either. I'm telling you this story to emphasize for you guys that clients will never be satisfied with what you offer them. They will always want more from you than what you are offering. And you should be aware of whether you can negotiate at all, what you are prepared to negotiate, and what are the red flags that will drive you to stop the negotiation and walk. And those can change, right? They can change over time. They can change depending on your particular circumstances at a given time. So, okay. Do you have questions about who decides these important issues in the attorney-client relationship? What questions do you guys have? Yes.
Are there reasons that you cannot turn somebody away?
Rule 6.2 says that unless there is good cause, you should accept a court appointment. But good cause can be, I don't have, my caseload is too heavy to offer competent representation, or, I'm a tax lawyer and this is a capital murder case and I'm not competent to do that, right? If you are contacted and the court says, I want to appoint you to represent this person in this criminal proceeding, definitely the rules say you should see if it is possible for you to do it. But we are not English and Welsh barristers. We do not have what they call the cab stand rule. We are always allowed to turn down cases on the grounds that accepting it would lead us to a violation of the rules of professional conduct. Outside of the appointment context, I don't know of any situation where the rules impose an obligation to accept representation. Okay. What other questions? Okay. So now let's move on to whose interests get put first. To some extent, this is pretty simple, right? The client's interests come first. But it gets more complicated when we start talking about how far you can go to protect your own interests before someone becomes a client. Okay? So, until that attorney-client relationship exists, the only duties you owe are the Rule 1.18 duties, which essentially amount to running conflicts checks and not letting people tell you all their secrets until you know whether it is permissible for you to represent them. Which is not the same thing as knowing whether you are willing to represent them. Okay. What is the easiest way to determine whether an attorney-client relationship exists? Yes, so.
With the contract?
Yeah. I promise. I'm not the bar exam. I'm not always trying to trick you. Sometimes it's really that easy. Okay. So an engagement letter that says, I have agreed to represent you on these terms. a contract signed by both parties that says we've agreed to representation with this scope on these terms, right? Unfortunately, unfortunately for you, fortunately for clients, the rules do not say that a contract or an engagement letter is required for an attorney-client relationship to come into existence. Last thing that we'll talk about today is the Tagstad case, and so that's going to be a case that gives us an opportunity to look at like how you can find yourself in an attorney-client relationship without any sort of documentary evidence whatsoever. But until that document exists or until the relationship comes into existence, you are allowed to look out for yourself, which means that you are allowed to offer terms in the offer of representation that are specifically intended to give you control over the course of the representation. Let me give you an example. And I checked last night. I have permission to send you this document, so I will send it sometime soon. But our contingency contract that I used when I was in practice was specifically approved by bar counsel for every state that we used it in. So you can actually submit your contracts to the bar counsel and they will tell you, these are things, this is fine, or they will say, you need to add these terms or you need to take these terms out, right? But they will tell you exactly what they want you to do. Our contingency contract explicitly said that if a client elected to disregard our recommendations on settling the case, so that was settling when we told them to keep fighting or telling us to keep fighting when we recommended that they accept a settlement offer. If they chose to disregard our advice, the contract immediately converted to an hourly contract, and all of the work that we had done up to that point was immediately billable and due. We never had a client disregard our advice. Because when you say to a contingency client, if you tell me to pound sand, you're going to owe me $40,000, they listen. So, but that was a contract term that we specifically drew to the attention of the bar counsel, that they said, yes, you can protect yourself in that way. You can take control over the course of the litigation in that way. Okay. Okay. Questions? Awesome. I will send that contract around to you this evening. Okay. So now let's talk about the Tagstad case. All right. Mr. Ward, can you, and I'm going to be calling on folks, but I know I've been advised that the Ichabod shop is still like whatever. So if you don't have the book, if you haven't had a chance to review the Tagstad case, feel free to pass without consequence today. So Mr. Ward, what the hell happened to Mr. Tagstad?
Much detail you want on it, but basically,
As much as you think is appropriate.
well, he died of medical malpractice, or at least it's a claim. He had, like, they misdiagnosed some blood issue that led to an aneurysm and died from it.
Okay, so Mr. Simmons, why do we care? This is not a med mal class. So why do we care that Mr. Togstad died due to a doctor's negligence?
Basically, they sought representation, and one of the attorneys, when Vanessa basically said, he thought they didn't have a case, but other, I guess, supervisor attorneys about the situation. And he did it in statute of limitations right now.
Okay. So Ms. Wackerly, I'm a little confused as I read this case. Maybe you are too. Maybe we all are. What is it that the attorney did here to create an attorney-client relationship?
She met with him and they discussed like the
Who's
surroundings.
she and him? Like they told me you had been to her and mentioned me to him.
Mrs. Togstad met with Miller and
Who's Miller?
Miller is the lawyer.
Okay.
And Mrs. Togstad relied on the fact that the lawyer didn't call her back after saying that he would meet with another attorney to see if there was a case. And so when he didn't call her, she assumed that there wasn't a case. So it was that reliance and on the meeting that they had, she took it as he was giving her legal advice on the situation.
Okay. Ms. Barral, does that seem reasonable to you?
It seems like you should have said, we're not taking your case, thank you. Maybe the problem is that you didn't say that.
I mean, we're going to get to the problem in a second, but like, does it seem reasonable to you that Mr. Miller is held to have given advice simply by not communicating?
Seems like it, because it seems like they had like a 45-minute interview with notes and specifically talked about it, and then he would call her or let her know, and he didn't. So communication is one of the standards.
Okay. Mr. Van Diest, do you agree with that?
Yeah, because he specifically said, like, if I think there is a case, I'll contact you, and if I don't, then I don't think you have a case. That is, because he said that, I think that counts as a advice.
Okay. Mr. Fort, what do you think Mr. Miller could have done differently to, avoid all of this mishigas?
Guess he could have called him. Terminating the relationship that way more expressly rather than having her rely on the thought that his omission to give her an answer was advice to not follow functions.
But I mean, isn't it true that part of the issue is that like this implicit advice was in fact wrong? That she did have a claim and he gave her bad advice or gave bad advice. Like would calling her up and saying, we're not going to represent you because we don't think you have a case, do you think that would have satisfied the court?
I'm not sure.
Okay. Mr. Ward, you're shaking your head.
I think he could have said that we don't think you have a claim, but maybe you should get a second opinion, or refer to the possibility that there is a case that they don't think there is, so maybe you should seek out other.
Okay, lots of hands. Mr. Thompson, then Ms. Olive, then Mr. Durkin.
He should have also let her know if they weren't going to represent him, that there was a statute of limitations, so she needed to seek in a timely manner. And he also, in the alternative, could have at least gotten permission for her to look at the hospital records to see if there was a case.
Ms. Olive?
I agree. Before he can say there is no case, provide the investigation you did that proves there's no case. What's the reason for the disengagement? And also to provide an SOL so she doesn't mess it up. If there truly is no case, there should be a real reason rather than just, there's no case, move on with your life.
Mr. Durkin?
It's kind of what Tom said. I mean, did the guy he supposedly consulted with, even testified that he thought if this situation had happened, that it was part of his ordinary care and diligence, that they should have informed her of the 2-year statute of limitations.
I think that's probably right? I think that you guys have sort of given us the contours of kind of what this communication needs to look like, okay? Decline letters or decline phone calls should say 3 things, right? We are not going to represent you. Time affects your ability to press your claim. And we are not expressing an opinion on the merits of your claim. Okay. In general, you are going to be much safer telling a potential client, I am not going to offer you representation because, right? Because they're going to want to know because I am not the lawyer for you. Now, the reason you're not the lawyer for them can be because their story is a hat full of snakes and you don't want to touch it with a 10-foot pole. But where I think Mr. Miller goes sideways is he expresses an opinion on the merits of the case. He says, I don't think you have a case. At that point, he has rendered advice. And so if you limit yourself to, I think you should look elsewhere for representation, then you are off the hook. Okay. All right. Ms. Feldkamp, can you, like, one of the things that troubles me about this case is, sure, Miller meets with Mrs. Togstad. How the heck is he supposed to know that he's also bought himself an attorney-client relationship with Mr. Togstad, right? Who, by the way, is dead and yet recovered 90% of the damages assessed in this case.
So how is he supposed to know that?
Yeah, like, you know, it really feels like, yeah, Miller made some mistakes, but also it feels like the court is hanging a lot around his neck that just doesn't sit right with me. And one of those things is you never met with Mr. Togstad. I mean, the man is dead. You're not, you never advise him. You never communicate with the estate at all. How are you supposed to know that you're gonna be liable to this dead man to the tune of $600,000?
Well, I think just because the case was all about him and medical malpractice, if he was his patient, then that goes without saying.
How do we feel about that, Mr. Durkee?
I also think he's dead. I think he's just paralyzed.
Oh,
And he can't.
someone said he was dead.
He didn't even he didn't accompany her.
Yeah. So, I mean, So, I mean, do we think that it's less problematic because he's in a hospital bed somewhere on a breathing machine, or I don't know, I'm exaggerating, whatever his situation is, right? You know, it's definitely true. He didn't meet with Miller. Do we think that the fact that he's not dead should make us more comfortable with this, random attorney-client relationship, or should we feel less comfortable with it because he's alive? We can't, you can't make an argument that, well, Miller should have known that Mrs. Togstad was going to be representing the estate as well. So what do we think? Yeah, Rusty.
I think that it's a more comfortable standard than if he was dead. I'm sorry, I can't remember who said it, but he is essentially the object of the case, and his wife is seeking representation. So I think it's pretty reasonable to assume that the man who was actually injured and suffered the damages would be considered part of the client relationship.
Do you think that your answer changes if there's a dispute in the testimony as to what claims they discussed? So, and let me be clear about this, right? So, there's the med-mal claim, there's the underlying med-mal claim for Mr. Togstad. Mrs. Togstad also has a loss of consortium claim, okay? And I don't know what your torts class covers, so you may or may not know what loss of consortium is, but basically, if your spouse dies or is injured in such a way that your relationship to them irreparably changes, you may be entitled to a claim beyond their claim for the harm that was done to them, right? Their death or their injury. You may also be subject to a claim for the value of the impairment of your relationship. And yes, sometimes this goes so far as asking, how often did you have sex before and after? What if Miller's testimony was that his meeting with Mrs. Togstad was limited to her loss of consortium claim? Yes, Mr. Green.
So yeah, but in the context that he would have maybe not established a relationship with Mr. Togstad, I would say, yeah, maybe, unless those two claims are codependent on each other in some way, like legal standpoint. But otherwise, I mean, yeah, he can't speak, he's paralyzed, so he's going to be operating through a proxy no matter what, seeking counsel. He can't do it independently. So I think it's a pretty strong implication that anything she discusses and also involves him. That anything the wife discusses with the lawyer also falls.
Anybody want to add on to this?
Can you just ask as an attorney? He should have asked.
And ask what?
Like, who am I representing here? Do you want me as your representative, or is it for the couple, for both of you and each of your claims?
I think that's an important point, right? You absolutely should be asking, who am I representing? What are the claims that we're going to be pursuing? Now, what I will tell you is that clients never know what their claims are. I literally had a conversation with a friend of mine yesterday, and I'm not going to tell you too much about it because, this is even though I'm not representing him, there's the Rule 1.18 issues. But basically, he's asking me about how to deal with the fact that his manager at work is pretty clearly managing him out the door. And so I gave him, I said, okay, these are some things that you can do to buy yourself some time, but if they want you gone, you're gone. It's just a matter of when, right? So we're buying you time to look for your next job. And so then he messages me yesterday and he's like, I met with HR today and they didn't want to talk about my complaints about my manager. I was like, because they don't care. They don't care. Like, why do you think they would? Like, even if I caught my manager in a provable lie, I'm like, no. So clients frequently think that there are things that are important that absolutely are not. Clients also will think that something doesn't matter when it is really important, right? So one of the strategies for helping this person sort of extend their time at this employer is asking for accommodation for their disability. And they're like, well, what's the point, right? What's the point? Because they're just going to grant me this accommodation and then in a couple of months, they're going to fire me anyway. And I said, well, the point is that if you do the accommodations process, appropriately and you take it seriously, then if and when they fire you, assuming that you don't find another job and quit, future you gets to decide whether you want to sue them. But if you half-ass the accommodations process, you are taking that decision away from future you, right? And so a lot of times when clients are telling you their story, they're going to tell you a bunch of stuff that doesn't matter. And they're going to neglect to tell you things that do. And you're going to have to draw out the things that matter. Okay. And here is what, here's where I'm going with this, right? Ms. Gleason asks, can't we just ask who we're going to represent and what the claims are? You absolutely can. But you have to ask that question more indirectly, right? What are the things that you're upset about? And then when you hear that, that gives you a sense of like, what are the contours of the space that we're working in? And then you can go, okay, here are the missing pieces from the story that you told me. So let me ask about those, right? And all the things that they've told you that don't matter, you just sort of let them talk. An awful lot of our jobs is sitting with someone who feels aggrieved over something and saying, man, that sucks. Sorry that happened to you. And that's it. It's an awful lot of our jobs. Okay? All right. We got about 10 minutes or so left. So let me throw this question out to you guys. And this is a question that does not have a right answer. So not going to be cold calling. And you should feel comfortable like putting yourself out there because there's nothing wrong or right here. Is the outcome in Tagstad, is it fair to Miller?
Yeah, I think the outcome was reasonably fair, but the amount imposed to me was quite outrageous. So that's I take exception to the damage was have to pay.
Well, this is not a remedies class, so we're not going to argue over whether the damages awarded were appropriate given the nature of the claim and the calculation of damages. But just in terms of like, is this fair? Is this appropriate? You say yes.
Yes, it's quite appropriate.
Why?
Because as lawyers, we should be able to take responsibility for our calling as experts in our profession. It is our duty to diligence in dealing with client-related issues. And then sometimes our relationship with our clients can be directly or indirectly be created with the words we use when advising our clients. So we should also be very picky when advising our clients. Because if you notice when he was arguing in court, he was really trying to, interpret advice in another context. But of course, court didn't find it wrong with that kind of reasoning, and then court really overruled it. So I think it's very fair.
Right. So Miller's argument is, look, I I didn't give any advice here, right? I just said, I don't think you have a claim, but we'll look more closely, and if we change our minds, we'll get back to you, right? So Mr. Odo says, like, that's splitting hairs inappropriately, right? That's straining at gnats. Is anybody who wants to sort of like think that maybe Miller's got something here? Yeah, Mr. Becker.
I just think that it seems to me like Mrs. Togstad's complaint is based on an unreasonable inference. Like, to me, I don't know that you could reasonably, it seems more reasonable that the other attorney doesn't contact you, so you call another attorney. It seems a lot less reasonable to infer from their silence a lot more than what that silence actually says.
Maybe, right? Mr. Knapp, then Mr. Simmons, and Mr. Clutby.
Kind of going along with that. I feel like, he probably should have been more clear and had his bases covered. But I think she was really serious about pursuing the claim. I think most people would infer from what he said that that firm just doesn't want to take that case, or she could have went somewhere else and talked to somebody else. But yeah.
I'm going to come back to that, but I want to hear from these guys. Mr. Simmons?
My question was, would it have been different? I don't know this case, but would it have been different in this case today? So like, would you have a simple phone call?
So the book actually makes this point that this case predates Rule 1.18. But I am not convinced that because the issue is, is there an attorney-client relationship under Rule 1.2, right? Rule 1.2 has not significantly changed since then. So I'm inclined to, I think there's room to argue that this case would come out differently today, that maybe Miller would be less on the hook because the duties to prospective clients are more clearly defined. But I could also see an argument that it comes out the same way because he still, like, he gave advice, right? So, Mr. Plesby.
I think it does come down to that a lot. He did give advice, but then he commented on the merits of the case. In any other instance, if he just didn't reply to her, made no comment on the merits, maybe she should just gone to another attorney. But he also did not perform with due diligence. He never asked for any of the medical records and commented on the merits of the case. I think that's where sort of the big issue in the case comes from, and where the decision stems from. If it wasn't for that factor, the outcome would have been different.
So how much investigation do you think should be necessary? Ms. McHenry?
So I don't have an answer to that question. But before this, I just feel like it would have been easier for her to infer that she should have just gotten a second opinion, like even getting a second opinion for like some car or whatever, like if the first place goes you $5,000 and then, I don't know, I just wouldn't, like, and that's kind of similar to the lawyer being like, oh, like, we don't have good chances. But you go to a second one, you get a completely different answer.
Well, how smart do you think clients are? Like, that question's a little glib, but I think it sort of cuts to the issue, right, Mr. Reeves?
Well, I was gonna say that even if someone is smart, people are smart in different things. We've been studying law for however many years now, and a lot of people don't. And so the lawyer said, you don't have a case. And to us, we understand that that means, oh, I don't want to represent you. But to a normal person, even if they're smart in something else, would be like, oh, this professional said, I don't have a case. And so I don't think it's as reasonable as some others may argue that she improperly misunderstood it because he said you don't have a case, and that's just kind of.
So what I will say is I think there are courts out there that will take the position of, like, you should be smart enough to go and ask someone else, right? So I don't think it's unreasonable or impossible to take the position that the potential client should have read into "we don't think you have a case" as meaning we're not willing to represent you and you should ask someone else, right? But as with, the Ohio, Minnesota, thank you. As with the Minnesota court, boy, Minnesota is a weird one. As with the Minnesota court, there are lots of places that will take the same stance as Mr. Reeves, which is clients are dumb and you cannot expect them to read into what you are saying. If you say you don't have a case, a client will go, "Yes, I don't have a case," right? And so lots and lots and lots of courts will take the stance of you have to be clear and precise because we expect you to play by the rules, not the client. Okay. Last thing that I want to ask, right? We're more or less, I think as a group, we're kind of coalescing on the idea that like probably the outcome here is at least acceptable. Like maybe if, maybe we think that a different outcome is superior, but this one isn't so wrong that it makes us jump up and down and tear our hair out. Here is my last question to you guys that we'll talk about today. Should we even care about whether these decisions are fair to the lawyers involved or not? Let me kind of explain what I mean by that, right? So, like, Miller's getting blindsided a little bit, right? He's been handed this attorney-client relationship he didn't think existed. We had a battle of the experts over whether the underlying claim was sound or not, and Miller lost, right? So clearly there's an argument to be had over whether this claim is sound, but he lost. And now he's on the hook for $750,000. So, there's a lot here that, feels like it's kind of landed on him without warning. And my question to you is, does that even matter? Yeah, it's pretty.
No, because it's just refining the duties that will be talked about moving forward if potential similar situations arise.
Does anybody want to agree, disagree? So you're okay with us declaring that this thing that we didn't know created an attorney-client relationship now does, and oh, by the way, the person who did it, not thinking that it created an attorney-client relationship, is now on the hook for the consequences of that change.
People don't like the outcomes of certain court cases all the time, but it furthers the application and validity of the rules that are going to be enforced moving forward.
Is all of you had your?
Yeah, no, I agree with him. So I mean, all the cases are with something like this doesn't seem fair, but this person lost. And to me, it seems fair that Mr. Miller lost because he still, despite he didn't know there was client, privilege between them. He didn't do his diligence as an attorney, like to start with, to actually investigate further to a proper conclusion rather than just an opinionated conclusion, which is like lawyering 101. You don't go based off opinion, you go based off fact. So I don't feel bad for him that much.
Ms. Brown?
I think we should care. We're all gonna be in the profession one day, and tomorrow it could be you in the position. I don't know why we're saying we don't care. We should.
Ms. Gleason?
I think that sometimes a person like Mr. Miller can be made an example to make a point to the rest of the profession too. We had another case in a previous assignment that they commented as such.
So it's okay for Mr. Miller to get thrown under the bus because we all get to watch that bus go by and go, oh, so that's what those wheels do to you. All right. We'll call that a day. All right. Thank you, guys. We'll see you next week.
You know what? People been doing this.